My name is Diana Fenton. I am an attorney here at the Department of Education, but honestly, just call me Diana. I only get Attorney Fenton when I'm in trouble, so which I try to avoid at all times. And let's see if I can get this to move. Oh, there we go. All right, so when we talk about the Code of Conduct, I'm assuming that people have seen this brochure, this little booklet that we put together at the Department of Ed. This is the Code of Ethics and the Code of Conduct. If you don't have this booklet, or you would like to have copies of this booklet, we have tons of them here at the department. And the reason we put it in a booklet is, I don't know if anyone's been on our webpage, but we have administrative rules for so many different things. And we felt that just kind of throwing this on our website and sending an email saying, hey, make sure you take a look at this, was not fair to the field. So we really wanted to put it in kind of an easy to read booklet. And so we do have tons of these that you are welcome to have. So when we talk about the Code of Conduct, I know it's easy to kind of equate that to punishment, but it's not about punishment. It is about process, because a good, solid process protects the good teachers who should be in the field, as well as allowing the Department of Education to root out and identify the teachers who are not safe around children, who might be causing harm to children. And I've had conversations with NEA at times where they say, well, you know, we're on opposing sides. And I say, I don't think so. I think we're on the same side, because we don't want teachers who are harming children in the field, and neither do you. And so I think we really have more in common than we do as differences. So it's really about process, and that's what we're going to talk about here today. Just a very brief history of the Code of Ethics and Code of Conduct, kind of how this all came together. Back in 2015, the PSB, and if you don't know what that acronym stands for, it stands for the Professional Standards Board. And that is a group of professionals from the field who get together and talk about what the standards for the field should be. So there are subgroups on reading specialties. There are subgroups on English, social studies, math, etc. And they began looking at this issue of whether or not the field of education needed a code of conduct or code of ethics. In the summer of 2016, Commissioner Berry then created an ethics task force, which was a smaller group. And so throughout that fall into the winter, the task force began its work on the Code of Ethics. But at the same time, a legislator brought forward House Bill 210, which required a code of conduct. So they kind of became on parallel tracks a little bit. And that was signed into law in 2017. And so then the task force, once it finished with the Code of Ethics, pivoted its work to focus on a code of conduct. And in the summer of 2018, the Code of Ethics was accepted by the state board. In November 2018, the Code of Conduct was adopted. The difference in language there, if anyone picked up on it, and I know someone's an English teacher, so the accepts versus the adopt. Because the Code of Conduct was not required by law, the state board could not formally adopt it. They had to accept it. But because the Code of Conduct was mandated by law, the state board had to adopt it. So we did this in partnership with a lot of different stakeholders. NEA was part of that, AFT, the Superintendents Association, the School Boards Association. It was really a lot of people at the table expressing their views. And for me personally, I can just share with you that I learned an enormous amount learning from the stakeholders. So just so you're aware, this is the statute that passed, and it sets forth the 4 areas. Oh, sorry, as I show you my thumb, it sets forward the 4 areas that they wanted the Code of Conduct to cover. And that's the A, B, C, and D. And so what we did was we did that for the Code of Conduct, and we mirrored it for the Code of Ethics. So if you look at the booklet, you will see that the principles, we have the 4 principles based on the law: responsibility to the education profession and professionals. Principle 2 is responsibility to students. Principle 3 is responsibility to the school community. Principle 4 is responsible and ethical use of technology. Those 4 principles are the same in the Code of Ethics as it is in the Code of Conduct. And there is one additional principle in the Code of Conduct that we will talk about, and that's the duty to report. And this is a provision, it is in our ED 500s, our 510s. And as I mentioned, anyone's had the opportunity to go onto our website and look at our rules page. But if you look at it, in my opinion, there's a lot there. And I used to describe it as a dumpster fire, but it was insulting to dumpster fires because dumpster fires are actually more organized. That's actually funny, by the way. So anyone out in cyberspace. So that is why we decided that this was so important to put it in a booklet and to kind of separate it out, cull it out from our website page. And the reason it's important, not only does it govern process, but it directly affects your teaching credential. Because just like an attorney, a licensed attorney, you are an educational professional, you're a licensed professional. So the difference ultimately between the code of ethics and the code of conduct, the code of conduct is that bottom line, bare bones, base level of professionalism. That is the stop sign. And if you violate one of those provisions, just like if you run a stop sign, there could be a penalty attached to that. The code of ethics is more about guidance. The code of ethics recognizes that teaching is a very difficult profession and it is hands-on, and you are with these children making so many decisions every day. And the code of ethics provides that guidance, just like the road sign that says, hey, it might be dangerous up ahead. You might need to slow down for this and consider your options. It was really startling to me not being from the field. I am not from the field. I don't pretend to be from the field. I don't have the patience to do the amazing work you do with children. And I don't pretend to have that patience. But as attorneys, we are heavily governed by our code of ethics and code of conduct. And yet we approach our clients in an arm's length transaction. Whereas teachers deal with students every day. You are just there one-on-one with kids, and kids are confiding in you so much. So much is put on your plate. It was surprising to me that the field didn't have a code of ethics or code of conduct, because it really does help you as a professional to navigate those sometimes tricky waters of ethical dilemmas that come up. So then the question becomes, who is this applicable to me? Applicable to, rather, sorry. As I like to say, are you talking to me? So the code of ethics is applicable to all educators and all school personnel. The code of conduct, which is actionable upon an individual's teaching credential, is applicable to credential holders only. And that term credential is defined in the code of conduct. And it's on page 9 of the booklet if you have that in front of you. So again, it is only applicable, the code of conduct is only applicable to credential holders. So why is the code of conduct and code of ethics important? At the bottom line, child safety is not a zip code issue. Child safety is something statewide. And I think if I were to put this training into a nutshell, it is simply that the department's role is much narrower than that of a school district's. The real key to the code of conduct is the difference between employment and licensure. And I always use myself as an example. There are a lot of things I do that could upset Commissioner Edelblut, right? I could violate the IT policy. I could show up late to meetings. I could violate the dress code, right? I could take a longer lunch than I'm entitled to. There are a lot of state policies that I could violate on a daily basis, and perhaps I do, I don't know. And that could affect my employment. And Commissioner Edelblut in the state of New Hampshire might fire me, and then I would go out and seek employment as a lawyer somewhere else, right? But still as an attorney. However, if my actions were so grave as to call into question the integrity with which I hold my license to practice law, so for example, if I was submitting documentation, travel reimbursements, saying, you know what, on this day, on May 11th, to do this training, I drove to Governor Wentworth. I drove all the way up to Governor Wentworth to do this training, and you have to reimburse me for my mileage. And they were to find out that that's not true, that I did it via Zoom from the Department of Education, then that would question the integrity. That's theft, right? And that would go further than my employment, and it might call into question my ability to really hold a law license and be safe doing so. And that's really the difference. And when we talk about child safety, we have to recognize that a school district only has jurisdiction within that SAU. And if an individual is harming a child and then they decide to resign or they're terminated from that district, that superintendent no longer has jurisdiction over that individual. So we run the risk that that individual will then go to other districts, and we've seen that happen in other cases. And that's where the credentialing piece, the code of conduct, and the Department of Education comes into play. Because the way I describe it is the Department of Education, our jurisdiction is much broader than that of a district, right? I have statewide jurisdiction, whereas a superintendent only has jurisdiction within his or her SAU. But the amount of things that are going to catch our attention, our scope, if you will, is much narrower than a district's. There are many policies that you can violate at your school district that will not in any way, shape, or form affect the code of conduct. So our real focus is not about dress codes. It's not about people showing up on time. It's not about any of that. It's really not even about curriculum. It's about child safety. So that's really what is behind and driving the code of conduct and code of ethics. And so I think when people recognize that the department's role and our focus is a lot more narrowly tailored than people might initially think, right? It puts it into perspective. So that's really it. Child safety is not a zip code issue. And if there is someone who is harming a child in Concord, we do not want that person to then go to Colebrook, because child safety in Concord is just as important as it is in Colebrook, and vice versa. So again, the code of ethics is guidance. It is aspirational in nature. It articulates those responsibilities common to all members of the educational profession, and helps to give guidance to those really tricky waters that sometimes arise. Whereas the code of conduct establishes that lowest standard of care, and it is actionable, but it is only actionable against credential holders, and it is applicable on or off duty. However, and we'll get into some case examples. However, in order for the department to take action on a person's credential for off-duty conduct, we have to prove a nexus to their ability to be effective in the classroom and their ability to continue to be safe around children. So if we can't prove that, then no action will be taken. And if you have any questions, please somehow raise your hand, flag me down in the land of Zoom, and I'm happy to have that discussion with you as we go along. So also a little bit of difference in language. The code of ethics, again, it's that aspirational language. And so you'll see an example: when communicating with students, utilize the social media responsibly, transparently, and primarily for the purposes of teaching and learning. That's really nice, aspirational, somewhat subjective, very broad language. Whereas in the code of conduct, it says very clearly an educator shall not engage in harassment, stalking, or bullying via electronic media. It's a lot clearer, much more concise, and a lot easier to say. It's less subjective. Again, employment versus licensure, we touched upon this briefly. Teachers are licensed professional, just like attorneys and doctors. Employment and licensure are very separate concepts. Again, there are a lot of things that could result in perhaps my termination from state employment that would not rise to the level of reporting my license to the New Hampshire Bar. And the way I've described it is the department's role, again, broader in jurisdiction because we go statewide, but we are narrower in scope. If you violate the dress code at your school, your employment, I assure you, I promise you, I do not care. I promise, I don't care. All right. So if you get reported for violating the dress code, I will be the first to say, I don't care. So the analysis, and forgive this crude diagram, but even my 9-year-old son made fun of it. It's really these three separate concepts, and sometimes they can overlap. They are separate and distinct, but sometimes they can affect one another. So you have employment, You have the code of ethics and you have the code of conduct, and sometimes they're going to overlap. Sometimes it's not going to be as clear as this, and that's where you kind of get into those Venn diagrams of one melting into the other. Again, you have those 4 principles based on the law in the code of ethics and the code of conduct, as we've gone over before. And the code of conduct, as I mentioned previously, has the additional principle 5, which is the duty to report. So before we go into the first principle, I want to go back and just talk about this idea of employment and licensure being separate concepts, and then see if anyone has any questions at this point. So the example I always give to highlight the difference between employment and licensure is this story. The Department of Education, we received a call from a district that had concerns about one of their employees. And their employee worked with children. She was a certified educator. And it came to their attention that she was also engaged in, she was an adult film star. And I got everyone's attention with that, didn't I? People are waking up from their naps, right? So she was an adult film star, and I wasn't sure what that meant. I didn't know if that's something she had done previously. I didn't know if that was, I had no idea. So we reached out to the educator, and she shared with us that this is something that she was actively engaged in, and that she had 2 very separate parts of her life. She was a teacher, she was engaged to be married, and she loved her job as a teacher, but she also had this very different part of her life in which she was an active adult film star. And everything related to that was under a very different name and password protected, and you had to pay to get into that site. And I don't know all the details, so forgive me if I'm somewhat vague. And I spoke with her at length about it, and she recognized that it was somewhat shocking to me, but she appreciated the fact that she had these 2 very different parts of her life, but she enjoyed both of them equally. And she said, you know, I would never do anything to harm a student. That part of my life, my adult film star career, is very separate from the work I do as a teacher. And they do not mix, and they do not come together in any way, shape, or form. And at the end of the day, the district took action, employment-based, because she was asking time off to go film a movie. And the district took their employment action. I think they terminated her contract. And the Department of Education said, doesn't rise to the level of licensure. We had no reason to take any action against her credentials. So she is still a certified educator. And I don't know if she's working or not. So that kind of highlights the difference between the 2. We get a lot of calls about like Facebook posts, right? And social media. So one of our earlier cases, we had a superintendent contact me, and she said, I have this younger educator, and she's sending out these messages, tweeting them. And I'm really concerned about the nature of the messages, and I'm going to send them to you for your review. I said, okay. So I took a look at the messages, and this educator, who was fairly young, she really liked her First Amendment right to free speech. Awesome. And she liked to tweet, and she sent out lots of thoughts about the district. She had very strong opinions about her math class. I think she called them a bunch of brats at one point. She had really strong opinions about the district. She liked to share things about her personal life and her roommate's personal life. And just, she had opinions, and she wanted to tweet them out. The district had concerns, and they took employment action, and they non-renewed her. The department did not take any action on her credential. The reason why is she has every right to have an opinion, and she has every right to have free speech and to share that opinion. It did not rise to the level of affecting her license. And so I'll go one step further with it. Was she harming children? No, she wasn't. She might have said some mean things, but she wasn't actively harming a child. And could she go to a district where she got maybe a mentor who maybe said, maybe we can do things a little differently? Did she have the opportunity to grow in her professional career and to develop potentially? And she could potentially be a really good educator? Sure. And so the department didn't take any action, and the district took whatever action it felt was appropriate to take. So I think those are some good examples of the difference, the real stark difference between employment and licensure. And sometimes it's really hard to define that line. But then when you look at cases like the Concord case, which I'm sure everyone is familiar with Howie Luong, and that he was having inappropriate sexual relationships with students. One was 13 at the time and the other one was 18. It doesn't matter the age. That is where the department is going to step in and say, we're going to take your license to teach, period. And I don't think NEA would contest that, because NEA didn't. So NEA didn't represent him. So that is where I say with confidence that there are a lot of times, sometimes we're on opposing sides, but more often than not, we can both agree there's certain conduct that cannot be around children. So more often than not, the department likes to defer to employment and say that's an employment issue, not us, and we move along our merry way. All right, so any questions at this juncture? And then we're going to get into the individual principles. How are we all doing there in the Zoom land?
I have one question that's in the chat from Bob.
Question, how are the cows? Are the cows enjoying the presentation? All right, good. Cows are happy, I'm happy.
The question is, what protects a district firing an employee in that adult film star situation? And how is that legal? And I guess that I'll take that since I'm the Unitary Director, so I'm the employment side of things here. And I think that the district would have the argument that there's a nexus between the employees acting and her teaching, even though she's trying to put up that firewall. And it would be, depending on where she is in her career, whether she's probationary or non-probationary, she has more or fewer rights to make the argument that there is no nexus between those two. But we would have to persuade the school board. The school board has final authority on non-renewal decisions unless the collective bargaining agreement has more higher standards. So it would be just whether the school board thinks it's appropriate or not.
Follow up?
Yeah, go ahead, Bob.
So let's say, like I heard on one district, a person went on a field trip on January 6th to Washington, D.C. and was videotaped partaking in the, what you want to call it, protest, demonstration, insurrection. A school board could interpret that two different ways. That's completely at their discretion. If they feel that that is, they could fire somebody for that, or they could come back a hero, depending on what the local philosophy is, I suppose, right?
How the school board handles it, right? So again, it depends on, so state law is the minimum standard, and that's, you have to have a due process hearing, meaning you have to have known that this was a rule you were violating. You have to have known that you violated it. You have to have actually violated it, and then the school board has to say, yeah, this justifies your termination, and don't have an appeal from that, and that's state law. You have an appeal, procedural appeal to the state board. But if you have a collective bargaining agreement, you can have higher standards than that and require that it go to a third-party arbitrator, an independent arbitrator, to work that out. Many agreements in New Hampshire don't allow arbitration, though. So something to keep, just to be aware of. Diana, any other questions for Diana? You know that I will keep on talking for the entire hour and a half, so.
So I'm going to just add another couple of case examples, because I know when Peter reached out, that was really kind of what they were looking for is, you know, you can write a whole bunch of words and put it in a booklet and call it a code of conduct. But then the question becomes, how is it interpreted? So I think I learned by case examples, and I certainly hope that they are helpful to you too, because I don't want to bore you with war stories, but I want to give you examples of how we interpret it. So there was a case a couple of years ago, maybe 2018, out of Bedford. So there was a guidance counselor who was charged with some sex crimes against a student. And this was on the news, so I'm not telling tales out of turn here. And there were some of her colleagues from a school she used to work with at Bedford who went and testified on her behalf in court. And it hit the news and it was a big to-do. And I think the superintendent lost his job and a guidance counselor lost her job and all sorts of things. So the Department of Education, I myself was in court watching that guidance counselor take her guilty plea, because we had a document for her to sign to surrender her license, her guidance counselor license. We did not want her in a school. We did not feel that was appropriate. And that's all we did. That was our only role. And I watched all these guidance counselors come up and testify. And I went back to my office and the commissioner came in my office and he was livid. And he's like, I can't believe they did this. It's, it's awful. I want their license. And I said, okay, I want an indoor pool. Nobody seems to care. I want a horse. I want all sorts of things. Nobody seems to care. I said, they have a First Amendment right to go into a public forum, which is a courthouse, and express their opinion. And the Department of Education will not touch their license. No, we're not going to do it. They have every right to do that. Was it an employment issue? Yes. Yes, it was. And I will tell you, I spent my entire summer taking calls from Bedford lawyers who were telling me how wrong I was until I convinced them that I was right. And so I'm very proud of the fact that the Department of Education never even opened a case into that. We never notified anyone. We didn't look at it. It was all employment. NEA was all over it. Right, Peter? Yeah, it was a big deal in your world, wasn't it? Peter is saying something profound, but he's on mute.
It certainly was.
Yes, it was a huge deal in terms of employment, but you didn't see my shiny face, did you, Peter?
Nope.
Nope, because I
Bedford is nice
summer.
and far away from here too.
What's that?
Fortunately, Bedford is nice and far away from me too.
Yeah. So that again kind of shows you that balance. Now, there are some cases that are much closer call, and sometimes we get it right and sometimes we get it wrong. So we had a case where a certified educator was hanging out with her daughter, I think it was her daughter and maybe the daughter's boyfriend for graduation, and they were taking graduation pictures. And the students had cigarettes. And it was just, they're being silly, they're being students. But they had changed the law. Did you know that it's illegal now for like 18-year-olds to have tobacco? I didn't even know this. The law is now at 19. And so those students shouldn't have had cigarettes. That violated the law. And so you had this picture that was posted on Facebook of a certified educator with 2 students, graduating students, with cigarettes in their hands. Employment, sure, maybe, possibly. Does it become a license issue? It was a much closer call. The only reason it caught the attention of the Department of Education was because it was, in fact, against the law. We went back and forth on it. It was a really hard call. Did we look into it? Yes, we did. Did we take action? At the end of the day, we did not. But did it catch our attention? Yes, it certainly did. And it caught our attention because it violated the criminal law. So that kind of gives you a flavor of what we look for. More often than not, if it is not directly harming a child, right? People who are having inappropriate sexual relationships with children, that is absolutely 100% without a doubt going to fall within our world. But if you are violating a school policy, in large part, it will not fall within our world, and we will defer to Peter and NEA to address it. All right, and we've had some, as I mentioned earlier, some very controversial cases that made the news, some cases that are going to make you turn your head and say, wait, this person's an adult film star and she's still working as a teacher. DOE, don't you care? I'm like, yes, we care. Of course we care. But does it rise to the level of affecting someone's credential? Keeping in mind that, again, if I lose my job, that's one hardship. but I can find another job as a lawyer. But if I lose my license, that is a much heavier penalty. And we're very cognizant of that at the Department of Ed. And I think it is for that reason that we really have to have our actions be very narrowly tailored. All right, so I'm going to go back to my PowerPoint if I can do it. Maybe. All right, there we go. All right, so again, this is our analysis. These are our principles, and we're going to go into the first principle. And bear with me here. I always use my booklet, so that is what I'm looking at as I look away from the screen. So the first principle is the responsibility to the education profession and the educational professionals. I'm not going to sit here and read this booklet to you. I would not do that to you on a beautiful day in May. What I'm going to do is a 10,000 foot overview, hit the high points, give you some case examples if we have any to highlight, and then we're going to move on to the next principle, because I assume that as professionals, you will look at the code of conduct and look at what governs you. So failure to report to your district if arrested for an offense listed in 189.13a. Oh no, she just went lawyer on me. What is she talking about? So RSA 189:13-a talks about criminal history checks for employment. So when you are hired by a district, you have to submit to a fingerprint check, and your federal and your state criminal histories are pulled and reviewed by the district. Within that statute, there is section 5, which is the V there, and there are a list of offenses which prohibit anyone from working in employment within the state, throughout the state, I should say. I have that list. I created a little cheat sheet of all the offenses, and I'm happy to send that to Peter and he can send that out, but I'll hit the high points. Murder. If you've committed murder, you can't teach in New Hampshire. Okay, that's first degree murder, second degree murder, and manslaughter. Aggravated felonious sexual assault, and sexual assault. That's New Hampshire's version of rape, kidnapping, incest, endangering the welfare of a child, indecent exposure, prostitution, child porn, and possession of child pornography, things of that matter. So there are a lot of offenses that are not on this list. So for example, DWI, theft, assault, criminal mischief, things of that nature. So as we get to this part of the training, people usually say, gosh, I wonder, it seems like Diana's pretty fluent in criminal law. So this is where I will share with you that I used to be a criminal prosecutor with the Attorney General's office. And my mother, who I've mentioned previously, the teacher, when I became a criminal prosecutor, was telling all our neighbors that I do something with criminals, but she's not really sure what. So I made her watch a Law and Order marathon to figure out what exactly I did for a living. And then I watched the Law and Order marathon to figure out what it was I was supposed to be doing for a living. It's a very good show. So those are the offenses that prohibit employment in the state of New Hampshire as an educator. So if you're arrested for any of those offenses, you have a duty to report. I will say as a quick aside, one of the things the department is working towards legislatively is for new educators. I want to show my grid video here. There we go. For new educators, when they apply to get their teaching credential, one of the things we are working to create, one of the systems we want to create here at the Department of Education, is that in addition to the praxis and your college transcripts, we, the department, are also going to run your criminal history. Because why should we credential people who are unemployable? That doesn't help the field. So we will be taking on that task so that when a district looks at a candidate, they can know that that person is at least employable via Section 5 of 189.13a. Now, districts have the opportunity to have additional offenses that they can look for and screen for, but that will not be the department's job. The department is just going to look for those Section 5 violations. And so that is something moving forward that we hope to put into effect coming this fall. All right, but that's again just for new teaching applicants. All right, falsifying professional qualifications. So if someone has a false transcript, things of that nature, and that does happen, we have had those situations occur. We might take action on that. Unlawful possession of a drug. We've had those cases occur as well. Possessing or being under the influence of drugs or alcohol on school premises or a school-sponsored activity where students are present. I want to talk about a couple of these bullet points here. So I'm going to start with unlawful possession of a drug. We had two cases with very different results that I want to highlight for you. So the first is we had an educator who was found to have heroin in her desk drawer in her classroom. And that classroom was open, accessible to students, and the desk drawer was not locked. And she had a very serious drug problem. It was very sad. And she brought heroin into the classroom. So the Department of Education, we took action on her credential. That case was in the news. She was prosecuted criminally for drug possession because any student could have had access to heroin. And that is behavior the department cannot allow to then go to another part of the state. Concerns about that. We had another case, however, where an educator, certified educator, had a drug overdose, survived, but a drug overdose at his home, not in school, not around students, and was getting the help that he needed to recover and address the underlying issue. The department took no action on the credential. There was no nexus to his work within the school, and we felt that he was getting the help that he needed. So those are two examples with very different results. And what the district did with that individual, I can't speak to that. Did they have some employment concerns? Perhaps, but it did not rise to the level of license, sure. Now, the last one I'll talk about on this one is the possessing or being under the influence of drugs or alcohol on school premises or a school-sponsored activity where students are present. So when we rolled out the code of conduct, this is kind of a fun story. I knew I'd get a bunch of phone calls about interpretation. You know, well, what about this? Can I do that? Can I do this? So one of the first calls I got was from an assistant superintendent who's now become a very dear friend of mine. So Mike called me and he said, we have some real questions about this code of conduct. And I thought, oh boy, here we go. And he said, our superintendent every year throws a really fun Christmas party at his house and all the administrators look forward to it. And it's just so much fun. And I don't think we can do it anymore because of the code of conduct. And I was like, what are you talking about? And he said, well, look at this provision. It says possessing or being under the influence of drugs or alcohol on school premises or a school-sponsored activity where students are present. And I said, but you're talking about a Christmas party. I said, is it at the gym? Like, is it in the English classroom? He's like, no, it's at the superintendent's house. I said, okay, so it's not on school premises. I said, is it sponsored by the school? And he said, well, no. I said, are students invited? He said, no. I said, okay, well then it falls outside of it. Here's the thing. I am not the party police. I'm not. I don't have a super secret party badge. Like, if anything, I'm going to be mad at you because you didn't invite me to your party. But I'm not the party police. I've had so many people ask me, like, can I go to a 4th of July barbecue and have a beer? I'm like, yes, I think you can. I think you have every right to go to a barbecue and drink a beer. Can I come too? And that's when people are like, no, you're a lawyer and you're very uptight and I don't like you. I'm not the party police. If you go to a barbecue or a Labor Day party or just because it's Wednesday party and you have a beer or a glass of wine or a margarita or fill in the blank with whatever beverage of your choice, I promise you, I don't care. I don't. The cows care more than I care. Right, Emily? Cows were upset by it. I don't care. So the best part of my conversation with Mike is I said, well, can I come to the party? Because this sounds like a really great Christmas party. And there was a beautiful pause and he said, no. So once again, didn't get invited to the party, but I'm not going to bust the party. But let's take it one step further because I then went to this district and they gave me some great hypotheticals. So they said, okay, well, what about if we go to this great pub in town that everybody apparently likes to go to? What if I go there, have a couple of beers, and then I go to the high school basketball game? Okay, I'm off duty, I'm on my own time, and I want to go to the high school basketball game because my niece, nephew, fill in the blank, neighbor, whoever plays on the team. I said, Okay, well, I don't think you're under the influence of alcohol, right? I'm assuming you're not bringing alcohol there. You're off duty. I said, I don't think it falls within the code of conduct. I said, but does it fall within the code of ethics? Maybe, maybe. Is it a smart idea to do? I don't know. I'm not here to guide you on that. Could it cause some issues? Yes. The reality is this: we live in a small state with small towns, right? As I mentioned, product of New Hampshire public education. I went to Kennett High School in Conway. Wolfboro. I see you down there. Right? So Kingswood, we were rivals. Love Kingswood. We went to a really small town, and so we knew everyone in town. So if you went out and had a couple of drinks and then you came to the basketball game, were we going to run up to you because you're our teacher and say hi and talk to you and all this stuff? Yes, of course. And could someone be taken aback because you had alcohol in your breath? Yes, potentially. So that's where the code of ethics comes into play, right? And that's more of an employment issue potentially, but it does not affect the code of conduct. Now, let's take the scenario and twist it again, right? School trip to Washington, D.C. Bob had mentioned this earlier. We had a case where someone was on the field trip to Washington, D.C. He was a chaperone. Anyone who knows me knows that, like, I love my child. I love children in general. I don't want anyone to harm them, but I don't have the patience to teach them. And I surely don't have the patience to be a chaperone on a bus to DC. I can barely stand sitting in the car that long. So this gentleman was on the bus trip to DC, and at the rest stop, got off and bought a 30-pack of beer and then got back on the bus to sit with the children. Yes, thank you. Thank you, Lynn. Thank you for that look. Yes, that's a problem. That's a problem. That's going to violate this provision right here. Possessing or being under the influence of alcohol or drugs on school premises or school-sponsored activity where students are present. That's where you're going to violate that by the letter of the code of conduct. And so this, I think it was an employment issue for sure, but it also came to our level to address as well. Okay. All right, so now if we are going to go to principle 2, real quick before I do that, are there any questions on principle 1? Because I don't want to waste your time. Any questions that I can address? Peter, anything? We're good. Okay.
My question is, Peter, 51001, Peter.
$510.01
is principle 1.
Right.
So credential holders shall exemplify honesty and integrity in the course of the professional practice. Question is, how about when an administrator tells a teacher to change grades?
Oh, we're going to get to that.
Oh, okay. Thank you.
It's a big one, isn't it? Do they do that all the time? I've never heard of this before. No one was changing my grades, and I wish they had, I'll tell you. Okay, so. All right, let's keep going. And Bob, if I forget that one, please just tell me and we will get back to it. All right, so principle 2, responsibility to students. Again, I'm just hitting the high points. If you want to read the code of conduct in detail, please, I would encourage you to do so. So failure to provide appropriate supervision of students pursuant to local policy, furnishing alcohol or illegal drugs to students, engaging in sexual activity with students, and soliciting participation in a sexual relationship. And the real key to this provision is that the term student is defined as up to 10 months after graduation. So let's talk about that. We have seen instances in which students graduate and an educator will say, oh, here's my cell phone number, give me a call. And we've seen a relationship occur shortly thereafter. And you know, those things do happen. I've talked to so many people from the field that say, oh, I know educators who have married former students and what have you. And that's fine. The Department of Education is not here to prohibit it, but we do want to recognize that there is a power differential. There's a power differential. And so it was actually the stakeholder group that came up with the 10 months. A lot of states define student as maybe, some period of time after graduation. 3 months, maybe 6 months. The stakeholder group here in New Hampshire was a little more aggressive and went to 10 months. Initially, the discussion was 9 months, but then the feedback we got was people automatically were like, oh, because that's the length of a pregnancy. And we thought, well, no, that's not what we had in mind at all. That was never our intention. But so we made it 10 months, but in no way, shape, or form was that ever crossing our minds. But what we want to do is recognize the power differential, right? To give that student an opportunity to go out, meet other people, maybe go to college, maybe join the military, join a career school, whatever the case may be, right? But to just break that relationship a little bit. Because we recognize that, that's part of how you meet people. It's part of our small town community. It's what we love. And, those relationships do happen, and there's nothing wrong with that, as long as we've allotted for that power differential to break. In terms of the failure to provide appropriate supervision of students pursuant to local policy, let's talk about that one a little bit. We deferred to the local policy because we had to have a standard. We are not talking about the time where an educator says, you know what, I have to take a phone call, and they step out of the class real quick, or ask someone to cover their class, or go down the hall to get a drink of water. That's not what we're talking about. What we're talking about is an absolute failure to follow the policy. And so we did have one case in which an administrator failed. He received concerns and reports about an educator having an inappropriate relationship with a student. And the educator the administrator rather, failed to follow school district policy, failed to follow Title IX, and never did an investigation, never followed up appropriately, never did anything. And so that was a failure to appropriately supervise, the failure to follow that local policy. And then that's when it went over to the Department of Education. So only in that limited circumstance will we defer to the school district policy. In terms of the other things, the furnishing alcohol or illegal drugs, I think that's fairly straightforward. And then the soliciting participation with a sexual relationship or engaging in sexual activity. There was a law passed last legislative session, House Bill 1240, which amended the aggravated felonious sexual assault law and felonious sexual assault law, New Hampshire's version of rape, as I mentioned previously, to say that educators, it is now illegal to have a relationship with a student, regardless of the student's age. And so it doesn't matter if the student's 18. If they are a student in the school, doesn't even have to be your student. The law now recognizes that that is an inappropriate relationship. And so we did send out a TA, a technical advisory that's on our website. I'm happy to share that with you. But the law has now recognized that that is inappropriate. And I think it was a very powerful statement to say, regardless of the age of the student, because so many times I have heard from administrators, well, the student was 18, so, and they kind of throw their hands up in the air. And I'm like, I don't know why we're doing this. I don't know what this is all about, because that person is a student and it's inappropriate while that individual is a student. And so now the laws has just made that clearer for administration. Any questions on that? And we'll go on to principle 3.
I do.
Yeah.
So Dana, you talked about, and I guess this gets into a legal question. You said that a failure to provide appropriate supervision.
Mm-hmm.
And in the case you mentioned, the administrator had information that a teacher wasn't supervising a student properly or was having an inappropriate relationship with a student. How much information does the administrator have to have before they become responsible? And I guess this is similar to like the reasonable cause, probable cause standard. Like where do you draw the line? Like there's a rumor, that's one thing.
Sure.
It could be something people are just saying in the hallways. Does that trigger an administrator's responsibility? Or does there need to be someone who says, I saw this teacher with that student doing this? That's, put it right on their plate, right in front of them. And I think that's one of the things. It's the rumor aspect that really makes life uncomfortable for educators, because rumors abound in schools, and administrators can think, They hear lots of things. And do they have to act on every rumor?
Well, it's a really good question. I can tell you in the case that we handled, it was by all definitions, it was egregious. So we kind of passed that threshold, if you will. I think that, and again, I think this is where I stumble a little bit by not being from the field, by not having that experience of working in a school. I can only imagine the amount of rumors that are heard. But I do think that there is a significant difference between rumor of, oh my gosh, did you hear about, Susie and Billy, student, versus, hey, did you hear that this teacher is having this relationship with this 12-year-old or whatever? That's very different. Because that's not a rumor anymore, Peter. That's a potential crime, right? When you hear about this adult who might be having an inappropriate relationship with a child, and I'm not here to give you legal advice, and each district will define their policies differently, and administrators should be well aware of the policies they have to follow. But in this particular case, in my mind, legally, right, you've just potentially reported a crime. So now we're out of the land of rumors and we're potentially in a crime. And so, yes, I think that is when an administrator has an obligation to act very differently. And so that's where your Title IX coordinator comes in as a key component of any of those harassment cases, anything like that. And so I think schools do have an obligation to refer those to their Title IX coordinator. That's why we have Title IX coordinators and potentially their SRO. Those are the very important roles that those individuals can serve in that school. So, it's hard to say because rumors can go on a spectrum, right? There's a spectrum of behavior. And the case that we handled was egregious. There's no doubt about that. But I think when you're talking about a rumor of an adult having a relationship with a child, that is a totally different ballgame.
So it's the nature of the rumor. So even if it is a rumor, if the nature of the rumor is serious enough, then there's an obligation to report that.
Again, I'm not here as the end-all be-all attorney.
Right.
Tend to be such a thing. What I can tell you is in our case examples and what we've seen, yes, those should be treated very differently because it could be a potential crime. And we've seen that. We've had that happen. So here's what I'm going to do, Peter, because you and I could probably talk about this and go back and forth for quite a while, and that would be really fun for everyone, except, like the only people who will enjoy it are us and the cows. So to spare everyone else that pain, why don't I continue with the presentation, and then you and I can continue to chat offline if you'd like to. Okay. Everyone, you can thank me later. So, oh, Lynn, you're usually the person who responds to my funniness. Oh, Lynn, you let me down, girl. All right, moving right along. So what I want you to take away, the takeaway for this is the term student is defined differently just for this principle and principle 4 that we'll get to, okay? So that 10 months after graduation is only for that engaging in sexual activity or soliciting participation in a sexual relationship, okay? So looking at principle 3, responsibility to the school community, accepting gifts or favors where there might be an actual or appearance of a conflict of interest. Gifts of a small amount shall not be deemed a conflict of interest. This is a really interesting provision. Here's what I've come to learn. As I mentioned previously, in my prior life, I was a criminal prosecutor at the Attorney General's office, and the rule was very, very clear. You cannot, you will not, you shall not accept anything from anybody. And if I did, not only would I lose my job, but I would lose my law license. And that was the right rule, because you wouldn't want a victim of a crime to come up to you and say, gosh, thanks so much. Here's a $20 gift card to Dunkin' Donuts. And reverse that around, you wouldn't want me as a prosecutor going up to you, Lynn, I'm going to pick on you again because you're right there. You're just perfect for me to pick on. You wouldn't want me going up to you and saying, gosh, I'm so sorry this happened. This crime happened to your family. And I did homicide work at times. So you wouldn't want me going, Lynn, I am so sorry this tragic event befell your family. And I will do everything I can to seek justice for your family. But real quick question, do you have a gift card for me or anything just to show your appreciation? Like, no, nothing? Oh, all right, well, I'll try to argue this case the best I can, Lynn, but you know, well, Dunkin' Donuts gift card would really help, right? You wouldn't want that, right? So that would be completely inappropriate. And we kind of took it to an extreme at times. I will share with you that at the end of, near the end of my first homicide case that I prosecuted with a co-attorney, the mother of the young man who was murdered approached us in the parking lot of the courthouse. And it was right close to Christmas time. She's a very, very kind woman, very nice family. And she approached myself and my co-counsel, and she had baked us a cake as a thank you. And she said, I know you've worked so hard on my son's case, and I really want to thank you for all your time and effort. And it was really kind. And she gives us this beautiful cake. And my co-counsel and I both, because we're socially awkward lawyers, we're like, no, we don't want your cake. And we ran away and we couldn't take the cake and we couldn't touch the cake. And it was such an awful moment, right? Because she was heartbroken that she couldn't give us this cake. And I personally like cake a lot. But it was like, but think about how that would look in the parking lot of the courthouse to potential jurors, to the media, where the prosecutors are sitting out there stuffing our face with cake, right? You wouldn't want that. But when we transition it to education, gifts are a part of your culture. It's just part of the field. And I have a 9-year-old son who is in 4th grade and is the product of 2 lawyers. And so he says obnoxious things to his teachers like objection and please rephrase. And he's lovely. He's a cute little thing, but he is the only child in the 2nd grade. And I'm not from the field. I don't pretend to be from the field. He had a worksheet with like little words and then you had to make bigger words. Anyone familiar with this? Anybody? The cows? Okay. So I got a phone call from his teacher, 2nd grade teacher, lovely woman. And she said, there's no real issue, Diana. I just want to let you know something just weird kind of happened with your kid. I'm like, not surprising. And she said, he's only 7 and I've taught the 2nd grade for a long time. And I've never had a student write the word inmate on their paper. But he saw the word in and he saw the word mate and he created the word inmate because his mom was a criminal prosecutor. So I use words like inmate. And so I had to do the mom thing where I'm like, I'm so sorry. I'll talk to him. He'll never happen again. It's all my husband's fault, right? And then I hung up the phone and I was like, my kid's a genius. I was like, yeah, my kids are awesome. So the long and short of that is I can't give my son's teachers enough gift cards and money and thank yous for putting up with that, right? Because like who wants to put up with the kid writing the word inmate in the 2nd grade? It's crazy. So I usually like hand them a blank check. I'm like, thank you so much. Just fill in a number and I'm sorry. So I get it. It's part of the culture and I love doing it. And I team up with all my mom friends, we huge gift cards and flowers and all this stuff. So, and it's fine. In no way, shape or form did we want to stop that practice with the code of conduct. But we do want to just say, just be aware of what that might mean. Okay. And how that might be perceived. But in large part, we do not in any way want to stop that practice. So the question always comes up, well, what about a bottle of wine, right? Can I accept a bottle of wine? So I always pose it back to people this way. And I'm going to watch my friend Lynn to see when she reacts to this story, because she's going to get it pretty quick. And then I'm going to assume everybody got it. Okay. So can you accept a bottle of wine? Yes. Yes, you can. But let's be smart about where we put it, where we keep it, things like that, keeping in mind that you have children around. Okay. So the way I answer it is I work for the state of New Hampshire. Now, no one gives me a gift because A, nobody likes me, and B, it's inappropriate for me to take any gift. But let's say that someone did give me a gift and I could accept it. All right. So I have a couple of choices. I could say to my boss, you know what? Someone just gave me a bottle of wine. I'm going to go put it in my car and lock my car and put it in the trunk, right? That's option A. I could do that. Or B, I could sit in my state sponsored office, right? In my state employment chair and use my state employment wine opener, bottle opener, right? Lynn, were you with me? Right? Do I have a state issued wine opener? No. You see where I'm going with this? And I could open the bottle of wine in my state office. Anyone with me here? Right? That's inappropriate. But are there ways that I can handle that situation so that it is appropriate? Yes, of course. And it's the same for educators. And I think it's even more heightened for educators because you work around students. And so is there a possibility that someone could steal that bottle of wine or take, I don't know. I don't work around students, but you need to make smart choices around it. And I had a principal tell me, she said, you know, every year they have a raffle at their school. This is before COVID. And everyone brings in all these baskets. And so 2 or 3 days before the raffle, the organization brings in all the baskets. And the big basket, the one that everybody wants, is the wine basket. And she said, well, I always take the wine basket and I put it right on my table in my office. And I can't tell you the number of people who stop and go, oh my gosh, are you drinking that? And I said, well, that's a really good question. So is it a code of conduct issue? No, probably not. You're not drinking it there. But is it a code of ethics? Is it a perception issue? Is it a professionalism issue? Yes. Could you put it in a locked closet? Yes, you could. You know, are there other ways to handle the situation? So in no way, shape, or form did we want to stop people from giving gifts to teachers, but we want you to just be aware of what that perception might be, what it might mean, okay? Misuse of funds for use by the school. We haven't had a lot of these, but every once in a while we do some of these cases. And it's only when it's theft, a theft case. And then here we go. Intentionally altering or misrepresenting student assessments, results, or official school records. Every year I get a question from the field. What if I'm told, so I think the example I've gotten is an educator was told, we don't give out zeros, but we'll give out like 50s, right? Does that make sense? Lynn, you're okay. Lynn is my beacon here. She is my lighthouse in the storm. So, so that was a scenario. And so the educator said, well, the student received, you know, a 50 or whatever, or a 0 rather, but I was told to give it a 50. Would I violate the code of conduct if I did that? And the department's response was, you know, really the spirit of that provision was about someone saying, you know what, Diana's kid is a real knucklehead. He didn't get a good grade, but I know where his mom works and she gave me a really nice gift card. So I'm going to change his grade from a C to an A, right? So that intentional changing for that one person. But if you're doing it to follow a school policy and it's applied equally across the board, it doesn't violate the code of conduct. That's not how it's been interpreted. So any questions on that? Because I know that's a question that always comes up.
We've had administrators specifically tell a teacher, change their grade because the SAU says, because they need to graduate.
And that is something that could be reported to the Department of Education. That could be something that we would look at. Yes. We would need more information than that, but that is something that we would, you know, we would be interested in speaking with that educator if that was the situation. Any other questions on that?
I'm sorry, Peter, I was going to send you this chat, but I forgot to. When a transcript is reported and a student has honors credit and has credit for an honors class, but it was embedded in another class in which the teacher had to deal with problem students. So in their mind, it really wasn't an honors class, but yet here it is, it's on the transcript. going to a college and you are saying this is it, but you as an educator feel that is not right, that's a fraud. Is that misrepresenting, or is that just simply subjective?
And I'm sorry, Bob, was that question, I thought that question was to Peter, or is that to me?
Anybody that has answers.
Peter, you're muted. Peter, you're killing me. You're still muted, Peter.
Oh, no. There.
There you go.
So I've already taken several stabs at that particular question, Diana. I think Bob's looking for your input on it.
Oh my gosh, Peter, way to pass the buck. And Lynn, way to not get me a drink when you went to your kitchen. Oh, you guys are killing me. You know, Bob, I'm going to give you the lawyer answer. And the lawyer answer is it depends. It depends on the particular facts. And I'm not savvy enough to sit here and say, yes, that would absolutely be a violation. But what I can tell you is, based on what you're telling me, is it concerning enough to catch our attention? Yes. And would I like the opportunity to flush that out? Yes. What I tell everyone is, if you have a question, call me, call Rich Farrell, who's the investigator. We are nicer than we look, and we're happy to chat with you. And along those same lines, I've had people say, you know, I don't know what to do if I have a colleague who might be getting too close to a student and I can't tell, and I'm not sure, I don't know what to do. Well, my offer to everyone is call me. We can talk it out. You know, we can run through it. And I always say this, no one in their right mind would ever put me in a classroom to teach children. Shouldn't do it. It's a bad, bad idea. I just don't have the patience for it, and I'm not smart enough to do it. But I'm very good at identifying individuals who should not be around children. Okay, it comes from my criminal law background, and it is my specialty. It's the child safety specialty. And that's what I'm good at. And we can have that conversation confidentially and just talk it out and say, yeah, there might be something to be concerned here, or maybe not. And so that's the offer I always give to people. And I think I put my cell phone at the end of this presentation, because as everyone here does, we all care about child safety. Each and every one of us. We all care about it equally. And we all come to it with different views and vantage points. And so if I can help kind of clarify an issue, I'm happy to do that. But I certainly can't sit here and say, yep, that would absolutely be a violation. This wouldn't be, that would be. I'm not that good. But what I can tell you is I'm always happy to talk to people and find out more information and see if it would fit within the code of conduct or not. Okay, it's the best I can do as a person. Lynn, still kind of mad about the drink, just saying, gonna keep it real with you, girl. So, all right, moving on. So, oh my gosh, here's our hypothetical. So the bottle of wine, am I going to lose my license? I hope everyone appreciates the graphic. I know it looks like a bottle of Robitussin. I apologize. Times are tough and we don't have a lot of money here at the state. We're in the middle of a pandemic, so I had to go with the cheaper version. So we've talked about the bottle of wine situation. Can you accept it? Yes. I'm not the fun police. I'm not going to bust you, but I do ask that you just use your best common sense and judgment and handle it appropriately. And my guess is there are employment and policy issues around that, right, Peter?
Probably, yeah.
Yeah, probably. Sure, we'll go with it. Probably more likely than not. You like that one?
I do.
Lynn?
It depends.
It does depend. Peter, you stole my line. That was. I had to go to 3 years of law school to learn that, Peter.
Right.
That line did not come cheap, I'll tell you. All right, so if anyone has figured out by now, I think I'm funny, but usually I'm not, so I apologize ahead of time. All right, so the fourth principle is the responsible and ethical use of technology. So let's talk about this. It's interesting because when this law was written, the representative who wrote it, his primary focus was on this particular principle. He felt very strongly about the responsible and ethical use of technology. And when we went as a stakeholder group to write it, I, for one, thought, gosh, that's going to be really easy to write, because at the bottom line, it's kind of just don't be creepy in email and text messages, right? Like just don't be creepy. But then when I went to write it, I realized, gosh, it's not that simple. It's not that simple, because it really is, when you look at someone who is conversing with an individual online and trying to have an inappropriate relationship with them, it's not a one and done moment in time. It is what we call a totality, right? It's a totality test, or a totality of the circumstances. We have to look at everything. So for example, we couldn't have a rule that just says, don't email people at 2 a.m. That's weird and creepy, right? We couldn't have a rule that said, don't send a student a text message with a heart emoji, right? Because I don't know about you, but every time I get an upgrade on my cell phone, I spend a huge amount of time, like really obscene amount of time. Peter, why are you texting me? Oh, Peter just sent me a text. That's weird. That's creepy. And listen, I'll be honest with you, no heart emoji. Should have used a heart emoji, Peter. Then I would have paid attention. So I go through all my emojis. Peter's telling me to wrap up and zip it. All right, so I go through all my emojis and I just send people text messages with all the new emojis. So I couldn't write a rule that was like smiley face emoji okay, but every emoji bad, right? Because what's that all about? So it is a totality test. And what we have seen in these particular cases is it is not a one text message. It is a multitude of text messages. The case out of Bedford, where the guidance counselor had the inappropriate relationship with a student, when the state presented its case, she had sent like, don't quote me exactly, but like 32,000 text messages to the student within a 3-month period of time. That's a problem. I text my husband every day, pick up cat, drop off child, try not to mix the two up, right? And I assure you, we don't have 32,000 text messages between us, right? So things like that. If we had an educator who was emailing students at 3 a.m, that was troubling. But guess what? He had an explanation for it. That's when he got up and that's when he started his day. Okay, not my jam, but so be it, right? So we look at everything. And again, for this particular provision, the term student is once again defined as being up to 10 months after graduation. We need to recognize there is a power differential. And generally speaking, when I speak to educators who have been in the field for a long time, I will inevitably have someone come up to me and say, I'm so glad that's in there, because I've seen so many times where educators will have these relationships with students, and it's so close to graduation. It has always bothered me, but there was never anything I could do about it. Well, now it's written down in the Code of Conduct. So moving right along, because I don't want Peter to keep texting me. That would be creepy. Right, Peter? Right.
That's right.
Nope. Muted now. Now he can talk back to me. All right. So in one of these cases, these were some of the things that the educator was saying in email to the student. You were one of my rare accomplishments. I saw special in you from the beginning. Let's put aside the fact that it's not correct. Even the cows know that. I felt compelled to both nurture and provocatively challenge your thoughts. Okay. So these are some of the things that we look at. And the fact that he was sending these at 2, 3 in the morning to the student, making her feel very uncomfortable, using heart emojis, it was inappropriate. And yes, it caught our attention. All right, so as I mentioned, the Code of Conduct has an additional principle, and that is the duty to report. So any credential holder shall report any suspected violation of the Code of Conduct. The superintendent, now that's up the chain of command. The superintendent has the obligation to report to the Department of Education. And so the question always becomes, well, what does that look like? So here's my rule of thumb, and Peter, I am aware of the time. Here's my rule of thumb. Educators, my experience is that educators are the best advocates for children. You beat any lawyer, you beat any CASA volunteer, any guardian ad litem. You are the best advocates for children. However, hey, the lady with the cows disappeared. It's just the cows. Oh, well, maybe oh, she's back. All right. I thought something had happened to Emily. It was just the cows. I thought the cows had eaten you, Emily. I was concerned. So best advocates ever. However, you are the worst self-advocates. You are, and that's okay, because if you were good self-advocates, guess what we would call you? Do you know what we would call you, Lynn? Lawyers. We'd call you lawyers, right? Because nobody can like self-promote and protect themselves like a lawyer, right? So when it comes to reporting, if you are reporting a violation of the code of conduct, please, 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 please do not do it in passing in the hallway during dismissal when like children are swinging from monkey bars and doing crazy things and be like, oh, by the way, I think there's a code of conduct violation. Please document it, please. That is my only request of the field. Please document it and cover yourself. Send an email, document it. Do whatever you do, memo it up, whatever it is, to document that you reported it up the chain of command. That is my one ask of you. And it is really the superintendent who has the obligation to report to the department. However, that does not prohibit you from calling the department and having those conversations. And we've had educators say, you know, I was really concerned with how my administration was handling this case, and I didn't know what to do. Could I call you? Yes, yes, you can. We've had people report to us anonymously, and that's it. It stays anonymously. We did get into a little bit of a dust up with NEA one time because we had a teacher report something anonymously to us. And then we were trying to take action on it. And NEA was saying, you need to tell who reported anonymously. We want to know. And I said, sorry, no, if I tell someone they're going to be anonymous, I have to keep that promise. So NEA was mad at me, but then they got over it. Now we like each other again. And Peter's going to keep texting me. So until I shut up, right, Peter? Pretty much. All right. So, you know, because really, I am a resource. Rich Farrell's a resource. DOE is a resource. And so you're encouraged to call us and use us. All right. So I'm going to go through this real quick because I will get you out of here on time. The code of conduct is one piece, but to me as an attorney, my concern was the process. Anyone can write a code of conduct and say, here you go, read this. But where the rubber really hits the road is how the department handles these cases. Because it is unfair to the department to say, hey, field, you have a code of conduct and an obligation to report if we do not have an appropriate working system in place to handle these cases, period. Because here's the bottom line. And just not me, but anyone, it is not a fair ask of a field to say, please report misconduct if the field does not trust the system will be fair. Same for lawyers. If I'm reported to the New Hampshire Bar, that's okay, because I know there are systems in place to protect me along the way. And the same is true for educators. We have created the 511 rules, which I'm happy to send to you, which set out our process. So here's the deal. We're going to go through it real quick because, again, a code of conduct falls completely on its face. It doesn't mean anything without process. That's my jam, right? Here we go, Lynn. You ready? You thirsty? Take a drink if you need it, Lynn. It's okay. All right. So what we do when we get a report at the department, and we get reports all the time, okay? We get reports all the time. We do an initial review, and the initial review is simply, is it employment? Is it licensure? Does it fall within our jurisdiction, right? If Emily were to report her cows to us, right, the cows might not ever know because you're like, well, the cows violated some barn policy. It's not it falls outside of our jurisdiction. So we would never notify the cows. We would never notify anyone because it's not our problem, right? It's the barn's problem, right, Emily? Cow problem. Okay, we're good? However, if the department feels that, yes, you know what, this is a licensure issue, and yes, there is enough evidence to substantiate it, like reasonable suspicion, if you want to use a legal term, then we put the person under investigation. And that is an actual legal, like that's a term of art. We place the person under investigation. And when we do that, we send a formal letter on DOE letterhead signed by the deputy commissioner, and it is sent certified mail to the credential holder and a CC copy to the union and to the superintendent. I had to go to 3 years of law school to learn that the term double secret probation, anyone know what movie that came from? Anybody? Animal House?
Animal House.
No. There's a long weekend coming up at the end. I watch it. It's great. So in Animal House, they had this joke term, double secret probation. He's on double secret probation. That's actually not a real thing. And at the Department of Education, if we're placing someone under investigation, Lynn, I'm going to pick on you again. If we're putting Lynn under investigation, guess what, Lynn? We're going to tell you, because it is unfair to the field for me to be like, don't tell Lynn, Peter, but she's under double secret probation, you know, an investigation, whatever. Like, don't tell the cows, but they're under investigation. That's not a real thing. So Lynn, and again, I apologize for picking on you, but if the department puts you under investigation, the first person who's going to know is you. You'll know. And the letter says to you, we are putting you under formal investigation for a alleged violation of the code of conduct. And then we tell you what the allegation is. And the reason we tell you that is because you have every right to fight it. You have every right to fight it. And we tell NEA, we CC a copy to NEA because NEA has a right to know what the allegation is. I can't just wave a magic wand and put you under probation or an investigation rather, and not tell you. That violates process. So you will be notified if you're under investigation, and the superintendent is notified as well. This is a copy of the letter, and it says, official notification pursuant to our rules that we have initiated an investigation into a complaint against you, which alleges a violation of the code of conduct. And then we go into the factual basis of it. Okay. So there are 4 options when we open a case. First and foremost, we can close a case out. And we do that often. And when we close a case out, we send a letter to the individual and say, we've reviewed this. It is unsubstantiated. There's nothing to it. And no action has been taken on your license. No action will be taken on your license. And I want to back up a quick step. If someone's under investigation, their license is still valid during that investigative period. And that's written in the letter as well. So Peter, real quick, I want to address that rumor question. We got a rumor case. We got a case of this track coach. Oh, I'm dangerously close on time. Will everyone be really nice to me and give me 10 minutes over, please? Lynn will buy everyone drinks. Lynn, right? Yeah, Lynn. That's right. Water's on Lynn. So we got a case of, and when it came in, it was horrifying. And it was a track coach who was promising dinner to these female track athletes and saying, whoever won the race, whoever was the fastest, got to have dinner with me on Saturday night. It was appalling. And so he was placed out on leave. The district was doing an investigation. The department was doing an investigation, and the entire thing was complete nothing, completely made up, nothing to it, absolutely nothing. And so we happily sent a letter to the superintendent and to the individual educator saying, this was absolutely 100% not substantiated. No action was, and nor any action will be taken on your license. We wish you the best of luck. Case closed. So we have and continue to close out cases. We can do a suspension, which is a period of time. We take action on that person's credential, and then that person can be reinstated and move forward with their career. We do want to support the field, and we recognize that sometimes, you know what, we're going to suspend someone. We're going to see if they can get the assistance, the help that they need, and then see if they can go back into the classroom and be effective. We used that once with an educator. I think is a great example. He had just had it up to here with his middle school class. Don't blame him. I couldn't do it. I think I've established that well enough. And in a moment of just absolute frustration, he turned around to his class and he said, do you know what you guys need? You need a good old fashioned school shooting. And everybody went, ah. And by the time the story got home to the children's parents that night, the fish had grown bigger, right? The story had been exaggerated, and he was charged criminally for his actions. And the department worked with him and his attorney to say, you know what? You absolutely right now need a break from the field. You cannot be effective in the classroom right now. So we're going to suspend your license for a period of time and then reinstate you and hope that you can address the issues you need to address to be effective in the classroom. Because our real end goal is twofold: protect children and support the field. A revocation is a permanent a removal of someone's credential. And we do that in very rare cases where there is a sexual relationship with a student, period. That's when you will see that happen. So in the Concord case with Howie Luong, his license has been revoked permanently. He is not allowed to ever get a license in any capacity from the Department of Education. NEA, you on board with that? I thought so, right? I think everyone can agree with that. So that is when we use that very strong tool of a revocation. And that's when people in the field would want us to do that. And a new tool that we have pursuant to our rules is a reprimand. And that is just a letter in DOE's file, not employment, DOE's EIS credentialing file that simply says, this was brought to our attention. This is a concern. So it really gives us a chance. I think of it as, you know, the rumble strip on the highway when you're kind of dozing off and you hit the rumble strip and it kind of it bumps you back in your lane, right? It wakes you up. That's how I view a letter of reprimand. It's just a recognition that it didn't rise to the level of a suspension or certainly not a revocation, but it was troubling. It was concerning. We needed to address it. Great example. During the pandemic, Peter, I know you're going to kill me because I'm talking and I keep going. So real quick example, and then we're going to wrap, I promise. We had an educator who in the very start of the pandemic had posted a video of her pouring a glass of wine and then doing this like joke math thing where she's like quarter full, half, 3/4, and then she downed the whole thing in one gulp and was like, empty or something, I don't know, something like that. And that was on her own time, right? But she was a health teacher. So all of a sudden there was a nexus to her ability to be effective in the classroom. And employment action was taken, and then it was referred to the Department of Education. And we met with the educator. I really liked her, honestly. She was great, forthcoming, just honest, came in and owned her actions. And we issued her a reprimand, and never before has someone liked me so much for issuing discipline. She would write to me and was like, thank you so much for that wake-up call. And I really needed it. And I recognized that it was unprofessional. And I really have an opportunity to kind of fix my behavior and move forward. And she has. She got a new job. She loves it. And she was the only person who was like sending me thank you notes for doing my job. She was like, you're the best. And I'm going to tell everybody I know how much I like you. And I was like, well, fantastic. Nobody else likes me. So, so for her, it was a really nice result because she appreciated the opportunity to keep her license. Right? Her license is still valid, but we just put a little note in our file, nothing to do with employment, to say, hey, if this continues to happen, then we might take action on your license in the future, but I don't think it ever will. And she was like, you know what? You guys were really fair to me and really good. And no problem. So, all right. So when we do take action on someone's credential, we do not do it lightly. And it's not just me sitting in my office coming up with these things. We talk about it as a team. So it's the commissioner, the deputy commissioner, myself, and the investigator. We look at the seriousness of the offense, any prior disciplinary record, potential harm to students, and the purpose of the rule that was violated. We take it all into account. All discipline is documented in writing. Again, there is no such thing as double secret investigation or probation. It's all documented in writing. The NEA attorneys will sign it and the credential holder will sign it. And it's maintained in our electronic credentialing file. We do have a list of suspended and revoked educators. The reprimand is private, that is not on our list. And that is maintained and that is provided to the districts on a regular basis. If someone is suspended and then they get reinstated, we take them off the list. They are no longer suspended, and this is not something that's supposed to follow you around forever. So that is how we are handling that issue.
Anna?
Yes.
Is there an appeal if someone's if someone gets a reprimand or if they're suspended? Is there an appeal or is there no appeal?
So if they're contesting it, they can go to a hearing. So we will propose discipline. If they feel like this is not fair, I'm going to challenge this, then the result would be to go to a hearing and the department would present its case and the educator could present their case. And we've had that happen before, and I will happily say the department has won and the department has lost.
Okay. Before whom is the hearing?
So the hearing goes to a hearing officer. So there are 5 attorneys who are on contract with the Department of Ed. And they serve as hearing officers, which are like quasi-judge roles, and they oversee the hearing.
Got it. Thank you.
Attorneys, NEA attorneys would represent the educator.
If they're members. If they're not members, they're on their own.
Good clarification, Peter. This is why you're here. So this is just an example of an agreement. And again, everything is signed by the credential holder. Nothing is done in secret. It's all above board, transparent. So very, very quick, because I'm way over my time. We do have one tiny part of our rules that does allow for an immediate suspension. It's very, very rare, but if someone is arrested for one of those offenses that we went over earlier, the Section 5 violations, then the department has the opportunity to do what we call an immediate suspension, because if they are arrested for an offense like that, they can't be employed. And so we feel they shouldn't have a credential either. They do have a right to a hearing within 10 days, an expedited hearing. So for example, there was a case recently in Concord where an educator was arrested for pornography, child pornography and solicitation. And the department did an immediate suspension of his credential. We had another case over the summer where an educator was arrested for soliciting minors to engage in sex acts. And we did an immediate suspension of that educator's credential. But it's very limited, very narrow scope, and it's rarely used, but when it is, there's a reason for it. And they have a right to a hearing. So I think that's it. So this part, the investigator who is not here with us today, that's his office number, his cell, and the same for me. It's always easier to reach me on my cell phone, and you are welcome to call me with any questions. And I keep moving this thing around, and it's so weird on my screen. Just makes me laugh. So before I let you go, and I apologize for running over, are there any questions? And for people who are going to take this back to their respective schools, my offer to you is I'm always happy to come and help co-present or ask any questions. I know, Matt, you were going to bring this back to your group. I'm happy to do the presentation, do it with you, whatever you're comfortable with. Any questions? Lynn, how are you?
I'm good, thanks. I'm not thirsty anymore. Thank you.
Well, I'm a little parched over here, but that's all right. Oh, Matt, thanks a lot, buddy. Jeez, you guys are killing me. Lynn, thank you for letting me pick on you. What's your question?
Okay, so my question has to do with the obligation to report, because a lot of us are, as representatives, have other members come to us with information, and then we have that information. And one of the situations that I was faced with this year was, so what if you find out, or if I find out that someone has been arrested and it's a felony level crime that they've been arrested for?
Mm-hmm.
Am I obligated, but it's not related to children, or then am I obligated to report that? And who am I obligated to report it to? Is it a building principal, the superintendent?
So it would, so in terms of who are you obligated to report it to, you report to your chain of command, which would presumably be the principal. The principal would report to the superintendent. In terms of, okay, they're arrested for, let's say, theft, right? Felony level theft. That is not one of the Section 5 violations. It would not be reportable to DOE. It falls outside the code of conduct. That's not to say we wouldn't be potentially interested in something like that, but we would have to prove that nexus. And the code of conduct says if they're arrested for a Section 5 violation, that's not one of them.
And assault is not one of the Section 5 violations.
So sexual assault is, but a physical assault, so like first degree assault, second degree assault, like a fist fight kind of thing, right? Simple assault is not.
What about assault with a weapon?
Nope. Arson is not a Section 5 violation. And we actually have an educator who has arson on their record, their criminal record, and they are a certified educator.
Diana, you're not supposed to tell people that.
Oh, sorry. Sorry. It was me. I'll just say it's me. Yeah. Sorry. It was Matt. Matt.
It was just the woods in my backyard. I live in Ware. We're all woods. It's
I
all
get
bliss.
it. I get it. It's no judgment. I did this presentation once, and a very dear friend of mine from high school was she's a wonderful educator up north. And so I was like, I picked on her the whole time. And I was like, it's Kate. She has the arson conviction. And she was so mad at me. I was like, this is why no one likes me. So what other questions? I think the one we didn't talk about is DWI, right? DWI is always the hang up for everybody. DWI is not a Section 5 violation, but let's talk about it. So we have had DWIs reported to the department very frequently. And here's our take on DWI. And this is not to say we don't take the offense seriously. We do. However, the question becomes, does it rise to the level of affecting someone's credential? The nexus is, does it have, is there a direct nexus to that person's ability to be effective in the classroom and safe around children? That's always the two-part nexus. In large part, when a DWI is reported to us, we can't prove the nexus. So if an educator is out on a Saturday night and gets arrested for DWI, I'm going to struggle to show that nexus to their ability to be effective in the classroom. However, I had a superintendent call me one time and say this individual was arrested for DWI. I just put them out on leave, and they were arrested this morning on their way to work. And that was a different fact pattern. And I said, okay, well, now we have a potential nexus to their ability to be effective in the classroom and safe around children. So that changed the dynamic a little bit there.
So if somebody is arrested for something that is not a Section 5, it might not reach the licensing level, but it could still impact employment.
Absolutely. Yes, it could. And that's where the worlds become very different and distinct. So you asked me the question, hey, if someone's arrested for a felony level offense, do I need to report it? My answer to you, Lynn, is your school policy, your employment policy might dictate that you do that. I don't know. I don't know where, I don't know what that policy is. That's a Peter question. In terms of, is it reportable under the Code of Conduct? The Code of Conduct is very clear. It has to be one of the Section 5 violations that has to be reported.
Or there has to be a clear nexus to employment.
That's not what the reporting requirement says.
Okay.
So if a superintendents in large part, if they hear about an arrest, or the reality is if we read about it in the paper or what have you, somehow it's brought to our attention,
Yeah.
Our analysis will be, is there a nexus? I have to draw a nexus to that person's ability to be effective in the classroom and safe around children. And the reason I reiterate that is the person who taught that to me and drilled it into my head was your attorney, Esther Dickinson. You were the first to tell me, you have to prove the nexus to be effective in the classroom and safe around children. So I thought, you know what? How do you beat a really good attorney at their own game? You adopt what they're telling you.
Mhm.
And so that, and Esther was right. And it's too bad this is being recorded because now she'll know I said it. But she was, and so that's the analysis. And so that is what we've adopted as our standard. So Peter, I guess the question is, does the superintendent have to report a DWI or report an assault or a theft or whatever? According to the Code of Conduct, they don't. They do, however, right? They like to report that. They want to cover themselves. Some of them have better working relationships with us than others, obviously, but more often than not, they will report that to us, or we will learn about it one way or the other. And that's the determination. That's the test.
Okay. All right, everybody. It's 20 minutes after 5.
I'm really sorry.
No, it's okay.
Thank you, Lynn. You're the
Everyone.
only person clapping and the only person.
Okay, thank you to Diana. Everyone was waiting for
Thank
my.
you very
Thank you,
much.
Diana.
I always
Diana.
appreciate it. So
I'll
if
need
you have
to say
Thank you,
you.
Diana.
call myself, thank you, Peter, for this opportunity. You guys have a great night.